Hello, I am Dr. Debashish Poddar. I am working as Assistant Professor of Law at National University of Study and Research in Law, Ranchi, in short NUSRL, Ranchi. Here the module I am going to present is the making of criminal law. Here we are going to discuss the legislative process side by side the executive policy making followed by judicial policy making about criminal law making. So, we will start with the policy making process which constitutes law making process as integral part of the same. So far as the making of criminal law is concerned, before we start the operative part of the lawmaking process, let us start with the policy making process, which is a background information for this module. Policy making, the most important part of governance in any country across the world. So far as policy making is concerned, lawmaking constitutes integral part of the same, but policy making does not start with lawmaking. At policy making process, first and foremost requirement is information. So far as the policy making process is concerned, the first and foremost requirement is information. The territory and its people, the government must have minute information before policy making or law making over the territory and its people. So, in that way, information is the first requirement. Once information is collected through systematic data analysis, thereafter it is a matter of identification. Identification talks about identifying the problem persisting in the society. In case of criminal lawmaking, identification of the social vices, evils, etc. These are most important database, and identifying this database, the real reason behind these menace, that is important. Once identification is over, thereafter it is the time for consultation. So, before lawmaking in a democratic process, what is required or desired is an engaged negotiation process with different stakeholders of the society. Once different stakeholders of the society are negotiated, informed, and thereafter given the opportunity to discuss, decide, debate, and determine the problem, real problem, and the proposed solution. Thereafter, this consultation process is over thereafter, and now it is time for soliciting the suggestions. Suggestions from different stakeholders helps the government to concretize the idea of policy making through lawmaking. Once this data collection, so far as the suggestions is concerned, this is complete. Thereafter, it is time for lawmaking. So, lawmaking comes as part of the process of policy making. Now, here in this discussion, we will be dealing with this lawmaking process with special reference to criminal law. Now, here the operative part of the making of criminal law, this module starts. As part of policy making, lawmaking in general and the criminal lawmaking in particular, this is an interface between crime and the law. Here, law is used as a social instrument to cure the social and albeit political evil. So, here we are going to discuss the interface between law and the crime. Now, at the very outset, this is necessary to mention that crime may not necessarily attract retribution. So, here a crime ignored by the state is no crime, since statute does not provide for how to deal with the same and thereby leaves the matter to the society. Thus, a mere moral crime is not crime, though the same may wreak havoc on the public life. So, in that way, there is no necessary correlation between criminal law and crime. A crime may not be part of the criminal law statute, and in that case, whatever heinous may be, the crime may not be a crime, whereas some otherwise not harmful for the society, that type of action or omission may be criminalized. So far as criminal lawmaking is concerned, in a democratic society, the lawmakers must avoid the social prejudices or individual prejudices or group prejudices from criminal lawmaking, because criminal lawmaking as a political process, it has its own vices involved therein. Now, the making of criminal law is usually associated with the law of crimes. Besides, there are procedural parts like Code of Criminal Procedure, Law of Evidence, etc. So far as law of crimes is concerned, an act otherwise not a crime may still get criminalized if the same attracts wrath of those in power. History is written with criminalization of acts difficult to comprehend as crime. At the same point of time, those crimes which are not statutorily liable to be penalized, those may not be held as crime. So far as criminal justice system is concerned, here there are several stakeholders that we are going to discuss. The way criminal justice prima facie refers to the law as if the same mediates two otherwise poles apart things, law and justice may not necessarily be so as such. As a social and albeit a political instrument to get played out by state apparatus, law appears charged with the mind of its own. So, in that way, law here, it is a conscious element working or getting played out on behalf of the powerful. So, at that point of time, those who are in seat of power, the characterization of law and justice is molded according to their ideological position. So far as the criminal lawmaking in India is concerned, if we go back to the history, in all society as such, criminalization or the consequent criminal lawmaking, it was not supported by any universal jurisprudence. So, criminalization, like criminalization, the making of criminal law, it is also a relative matter. From time to time, criminalization or criminal lawmaking, this happened to get changed with the passage of time, depending on the dominant social values, economic, social, political conditioning of the time and space concerned. Since time immemorial, while dealing with crime, state takes recourse to institutionalism. Modern version of such institutionalization lies in several components of institutions, like legislature. So far as legislature is concerned, this is the bridge between policy making and lawmaking as such. Legislation is not an accidental phenomenon. Before legislation, lots of groundworks are getting done by modern legislature. So far as the policy making process is concerned, legislature starts with the policy makers at first, and thereafter, in course of policy makings, when the matter culminates into law making, the process of legislative process or legislature starts its works. Besides legislature, there are other stakeholders also, like trial court, police station, judiciary. So far as trial court is concerned, it is meant for the court of first instance. Here the trial starts, but before the starting point of trial, as per the legislative process, there are many other things to happen. So far as criminal lawmaking process is concerned, after a particular matter got criminalized, and in case if that deviant attitude is caught in the society, in that case the matter starts with the first information report. So, as per the legislation, police station is the place where the matter starts. So, the making of law, criminal law in particular, may get divided in two parts. One is police process and another is judicial process. So, after the legislative process is over, thereafter the police process starts, and where the police process ends, the judicial process starts, and the matter culminates into the judicial policy making decisions followed by order and judgments as the case may be. So, legislature, police station, trial court and the judiciary, this is the process which the making of criminal law follows. So, here there is a distinction between trial court and the judiciary. Trial court is used as the first instance, the court of first instance. So, once the trial court arrives at its decision, thereafter the judiciary, usually the constitutional courts, that is meant for the appellate jurisdiction or appellate authority in the process. So, trial court while takes care of the matter at first, judiciary takes care of the substantive law part, and in case if there is any error took place, these are the distinctions between the trial court and the judiciary. So, legislature, police station, trial court followed by judiciary, this is the complete lineage of the making of criminal law. Taken together, these institutions jointly and severally constitute the criminal justice system to take care of the criminal governance of the country. So, here like criminalization, in the process of criminal lawmaking also, there are several binary opposites operative in the criminal justice system. This operates on these following binary opposites like pain and pleasure, vices and virtues, harm and help, innocent and criminal, etc. Since the time of Bentham, these binary opposites are getting played out to take care of the criminal governance. Pain and pleasure, this is the cardinal principle of criminal lawmaking. Accordingly, the given system attempts to encourage the former and discourage the latter. In this way, criminal lawmaking takes care of the process as part of national governance. So, basically this is based on the earlier ancient wisdom of India that to protect the innocent and to condemn the other people who are delinquent from the accepted or established behavior of the given time and space. Now, we will be dealing with the taxonomy of criminal law, the way offences are categorized by Bentham. Bentham categorized these offences in this way: private offences, reflective offences, semi-public offences and public offences. All these have had subdivisions of their own. So, now we will be dealing with the private offences. Private offences are those which are injurious to others assigned other than the delinquent himself. Also, offences against the person, offences against property, offences against reputation and offences against the condition concerned, all these constitutes the private offences. Private offences are usually targeted to other stakeholders of the society. Now, second, reflective offences. Reflective offences usually takes care of the self, the person or interest of the accused concerned. Thus, reflective offences includes offences against one's own self. Suicide is a classic example to this end, those by which the delinquent injures nobody but himself. Suicide may be cited as a classic illustration, as I told. This is but a contentious case and the same deserves contemplation. So far as harm theory of criminal law is concerned, here as you find obvious that reflective offences does not harm other people in the society or other stakeholders in the society. So far as the injury to self is concerned, whether or how far this may be criminalized, that is a concern for all the society across the world. So, here in India we have seen that the way suicide has been decriminalized in 1994, again criminalized in 1996, And very recently in the mental health bill, we have seen that suicide is again almost decriminalized, in the sense that at present, as per the given position of law, the onus lies on the prosecutor to prove that a particular suicide is not without extreme mental stress. So, it is almost difficult to establish. Third, semi-public offences. Semi-public offences are those which affect a portion of the community, not the whole community as such. A distinct, particular corporation or a religious sect, a commercial company or association of individuals united by some common interest, but forming a circle inferior to the community. In effect, however, there is little difference between semi-public and public offences, since both creates widespread unrest to the society. But the basic difference between semi-public offences and public offences lies here, that semi-public offences, it is pervasive but not pandemic. So, entire society is not affected by semi-public offences, but at the same point of time, it must be said that semi-public offences, in effect, it may go pandemic and thereby may dilute the difference between semi-public offences and public offences as Bentham categorized them. So far as public offences are those which produce some common danger to all members of the state alike or to indefinite number of non-assignable individuals, although it does not appear that anyone in particular is more likely to suffer than any other. So, in that way, there is a comprehensive treatment in case of the public offences. Few illustrations of public offences may be offences against external security, offences against justice and the police, offences against the public force, offences against the public treasure, offences against population, offences against national wealth, offences against the sovereignty, offences against religion and the like. Thus, public offences, it is much more detrimental to the life of the society and the state. Here, what Bentham avoided is the offences against the state. At later point of time in several countries including India, offences against the state also has attached an additional value to the making of criminal law. So, accordingly, offences against the state extends the same jurisprudence of public offences, whatever is detrimental to the life and stability of the state concerned. In the process of criminal lawmaking, judicial policy making constitutes a very important part. In course of criminal lawmaking, judicial policy making, this constitutes an important part of the project. Now, in course of judicial policy making, there are several things to be taken care of. Judicial policy making requires very attentive mind to distinguish between the bona fide interest and mala fide interest, to balance between several conflicting and competing interests in the society. So, at bottom, judicial policy making is administration of criminal justice, which is engaged in judicial policy making for the state through the same, not necessarily be called judicious, despite the same should be. So, here there is a distinction between judicial policy making and judicious policy making. So, all judicial policy making may not be judicious, while all judicial policy making ought to be judicious. So, here the teleological end of judicial policy making is judicious policy making, which the judges must take care of this part. Judgment in the Delhi gang rape case constitutes a paradox between gender justice and child justice, for instance. Here in this judgment we have seen in course of judicial process there are conflicts between gender justice and child justice, in the sense that whether or how far the age of 18 should be the age of majority. So, here only on the basis of a sporadic case or a few cases where even child went criminal. So, on the basis of these few sporadic cases, whether or how far the age of majority should be lowered, that is a contentious issue and it needs review for better policy making in terms of judicial policy making, which must address judiciousness also. So far as taxonomy of crimes is concerned, here we need to take care of two types of crimes in the society. One is violent crime and another is non-violent crime. The judicial policymakers must take care of different treatment with these two while they are poles apart in the West. Non-violent crime like omission, also IP and white collar crime in particular, deserves different approach by criminal justice rather than mundane violent crime. So, in case of violent crime, the way retribution theory is applied in general. In case of socio-economic offences which are largely non-violent in nature, they deserve different treatment. But at the same point of time, there is a critique against this policy making, because though they are non-violent in nature, but socio-economic as offences in turn, they may wreak havoc much more than the mundane violent crime. So, for instance, violent crime, if we take murder, a person committing culpable homicide, he takes one life at one point of time. So, though it is violent crime, but life which is compromised is one. But in course of the socio-economic offences, millions of life may be at stake out of deprivation of their property or legitimate interest, which may hit the society much more harder than a so-called violent crime. So, the distinction of violent crime and non-violent crime, the way it has been done so far, that is also a contentious point. In the Indian legal system, there are several instances of statutory law which constitutes the part of lawmaking. The Indian Penal Code 1860, the Evidence Act 1872, the Code of Criminal Procedure 1973, also the Police Act 1861, the Prison Act 1894, the Provision of Offenders Act 1958, etc. Especially the archaic law of the land like the Police Act of 1861 or the Prison Act 1894 requires completion to get updated. So, in this list, if we take care of all these constituents of this inventory, the Indian Penal Code 1860. Now, here we find that at later point of time, there are few provisions in the IPC which went contentious. The queer rights, the criminalization of the queer movements, the queer behaviors, this has become a contentious issue so far as section 377 of the IPC is concerned. So, this type of delinquent behaviors at one point of time, but now with the passage of time this has been decriminalized in popular perception, that requires contemplation of the legislature. So far as the Evidence Act 1872 is concerned, whether or how far the same deserves treatment, the same treatment in the digital world, that has become a contentious issue, because digital world requires different norms of the evidence jurisprudence. So far as the Code of Criminal Procedure 1973 is concerned, this requires contemplation in the sense that it is alleged that the Code of Criminal Procedure 1898, perfect criminal law, the procedural law is concerned, that has been replicated in 1973 by and large, except several facelifts here and there. So, whether or how far we require a same code of criminal procedure of the British India, that requires our contemplation. So far as the other procedural laws are concerned, the Police Act 1861, the Prison Act 1894, these two has been archaic in terms of its 150 odd age. So far as the Police Act 1861 and the Prison Act 1894 is concerned, critics are of opinion that these also require contemplation with the passage of time. The Probation of Offenders Act 1958, this is also a backdated provision because today the probation jurisprudence may be updated in terms of victimology. The Probation of Offenders Act 1958, this also required to be updated to keep pace with time. So far as limitation in the lawmaking, especially criminal lawmaking is concerned, appellate jurisdiction is the first concerned. So unlike US where appellate jurisdiction or gateway to the federal court or Supreme Court USA is very limited, in India by courtesy Article 136 of the Constitution, appellate jurisdiction is wide open. So far as appellate jurisdiction is concerned, in USA the appellate jurisdiction is highly limited, while in India by courtesy Article 136 of the Constitution, the gateway to the Supreme Court of India through appellate jurisdiction is wide open. So whether or how far this appellate jurisdiction and its wide coverage, this is creating a menace to the judicial system that requires contemplation. Because in appellate jurisdiction, ultimately it is not serving the purpose because it is actually lengthening the judicial process, sometimes multiplying the judicial process also. Likewise, plea bargaining. Plea bargaining, as it is recently enacted in the Code of Criminal Procedure and overall the criminal legal system of India, that requires contemplation because plea bargaining has its own positive sides, but at the same point of time plea bargaining encourages out of court settlement, and whether or how far criminal justice may afford out of court settlement, that has become a contentious issue. Third one is reversal of onus of proof. Reversal of onus of proof, this is another issue because there is no settled principle that where the reversal of onus of proof will happen, because reversal of onus of proof is anyway departure from the common law system. Now, in special cases, reversal of onus of proof is serving the purpose, but at the same point of time, nowadays reversal of onus of proof is increasingly taken care of, which is an emerging concern for the criminal lawmaking. Last but not the least, judicial policy making. Judicial policy making, so far as the price of justice, the lawyers, court birds, the people who are frequent in court, these people are concerned. In the common law system, the price of justice, last but not the least, is the bar. In common law system, the bench and the bar, this combination is the fitting combination, but so far as the irregular practice taken resort, another area of concern is the bar. The common law system usually takes place in combination of the bench and bar, but the irregular practice which are taken care of by the stakeholders of the bar, that inflicts more harm than help to the criminal justice system. Likewise, the court bars or those people who are frequented in court like professional witness, etc. Besides the irregular practice by stakeholders of the bar is concerned, another area of concern lies with the people frequented in court. Usually they are called as court bards. Now, the irregular practices indulged in by these courtiers, say for example, in the form of professional witness, these offer more harm than help to the criminal justice system, and the making of criminal law gets defeated by these elements. So, courtroom or the court premises must be freed from the court bars. Thus, to conclude, we may arrive at some points that law is no panacea to cure all sundry social evils until society stops producing them by default. More fundamental sidelines to conclude, we may arrive at these points that law is no panacea to cure all sundry social evils until society stops producing them by default. More fundamental side lies in mass production of crime, and the same deserves contemplation beforehand. Social reforms appear more critical to the reforms in the given legal system. So, at last we may conclude with this wisdom that prevention is better than cure. So, we need to take care that the system must stop or at least minimize to produce crime rather than to cure crime through the making of criminal law or criminal justice administration. With this, we conclude the session of the making of criminal law. Thank you.